Good evening. It's Wednesday, September 10th at 2014. It is 5:36. It is the monthly meeting of the Urbana Human Relations Commission. Could we please have a roll call?
Francis Rigberg Baker. Kevin Bauer Sox Johnson.
Here.
Daniel Larson.
Here.
Lisa Mosley. Peter Resnick.
Here.
And Aisha Lam Sobe.
Thank you. We can't really, we can't really approve the agenda or the minutes?
Without a quorum, no.
No. So we are going to skip those. And public participation? Seeing none, hearing none. To borrow a phrase from Marion Knight, we will move on to old business. Todd, do you have some information about union membership demographics?
Sure. Actually, what I would ask is that we table that sort of until we get to
Sure.
B of new business,
Sounds good.
because I'm sort of rolling those into one.
All righty, then let's, should we move to new business?
Sure.
All righty.
All right. I wanted to spend some time talking about the prior conviction enforcement rule and the Illinois Job Opportunities for Qualified Applicants Act. I'm not going to say that correctly again, so. And what I've done is I put together a very concise presentation talking about that sort of discusses both of them and introduces the Opportunities Act for anyone who's not familiar with it. So the point of the presentation is to summarize the Opportunities Act, to explore the interaction between that act and our prior enforcement, our prior conviction enforcement rule, and to review the key distinctions between the two and answer any questions that may come up. So it was signed, the Illinois Job Opportunities Qualification Applicants Act, or whatever I said before, the Opportunities Act was signed into law by Governor Quinn on July 19th. It's effective January 1st. It applies to private sector employers that employ more than 15 or more employees. Covered employers, and the gist of the act is that covered employers may not inquire into or require disclosure of an applicant's criminal background until after the applicant has been determined to be qualified and selected for interview or conditional offer of employment, or the reciprocal. The Opportunities Act has certain exceptions. First of all, it excludes or exempts employers who are required to exclude applicants with specific convictions under state and federal law, and that's very similar. For instance, the Health Background Check Workers Act would do that for most hospitals and nursing facilities. Where the position has a fidelity bonding requirement, basically where there's a bonding requirement for the position, and where the conviction would disqualify the applicant from being able to obtain the appropriate bonding that's required of the position. And finally, employers who hire individuals under the Emergency Medical Systems Act, Service Systems Act. Yes, sir.
The exception, is this exception simply that they can ask ahead of time, or they can throw away they can simply ask have you been convicted of a felony and throw it away?
My understanding is that since the act would not apply, they can ask ahead of time. So the prohibition on the inquiry and the request here that you see, so the prohibition on inquiry or required to disclose is not, it's not the case for those who are under the exception.
And it is per job, or it is per employer?
It sounds like it's per employer.
Interesting.
Their rules have not been promulgated yet, and that's the type of detail that rules may do, because this is a relatively short piece of legislation. But at least on a strict reading of the text, it appears that they're speaking about employers rather than jobs.
Okay, thanks.
So, so to note, the Opportunities Act does not prevent employers from notifying applicants in writing of the specific offenses that will disqualify the applicant from employment. in a particular position due to federal or state law or an employer's policy. That last point is very important, the employer's policy. Enforcement will actually be handled by the Department of Labor. They will enforce the provisions and propagate administrative rules as necessary, as they deem necessary. In terms of the penalties, for the first violation, you receive a written warning with a 30 days to remedy. Second violation, a civil penalty up to $500. Third violation, civil penalty up to $1,500, and subsequent violations, $15 per 30-day period of noncompliance. Now, the one thing to understand is also there is a running, so if you get a violation and you fail to remedy that violation within the 30 days, then you move to a second violation, even if there's not a new violation, right? And so it sort of continues
Rolls
that.
over, kind of?
I'm sorry? Yes.
Rolls
Yes,
over?
sir. Exactly. So, just a reminder of our language, and this is as much for the audience and the public as it is for everyone here. Section 1237 of the ordinance of the Urbana Human Rights Ordinance designates prior conviction as a protected class. So it is a protected, or a class protected from illegal discrimination in the same way that race and gender and sexual orientation and national origin is. The section 1262C prohibits employers from using written or oral inquiry in order to discriminate. Section 1262F2 prohibits them from indicating such preferences or discriminatory preferences in job advertisements. And then Section 12105A creates an exception when the decision that the employer makes is deemed to be reasonably necessary to the normal operation of business. So that does create an exception where an employee may apply who has a prior conviction. And if that conviction is deemed by actually ultimately the commission that it would be reasonably necessary to exclude that individual based upon that conviction and based upon the nature of the job that's sought, then that would constitute an exception to the rule or to the prohibition. Another reminder, since there were many questions about this, or there was much confusion about this in the written comments that we received earlier, the prior conviction protected class has existed since the inception of the ordinance in 1975. So since 1975, it has been unlawful to refuse to hire an applicant solely based upon their prior conviction record. So the guidance that our office issued did not change or modify any existing law. The guidance really sought only to explain how we are going to evaluate the charges. Now, a couple of things, and I mentioned this before. Employers may deny employment to individuals based upon a prior conviction only when the employer can establish that that denial is reasonably necessary to the normal operation of business. Covered employees under the rule can only ask about an applicant's conviction status once a conditional offer of employment has been made. That actually sounds very similar, right, to the Opportunities Act. So what are the key distinctions? The Opportunities Act mandates a process. It gives procedural rights to individuals who are seeking jobs. It basically, when can a background inquiry occur, a criminal background inquiry occur? The enforcement rule mandates a similar process, very, very similar process. And in fact, for instance, the enforcement rule says that you can only make that inquiry upon a conditional offer of employment, very, very similar to the Opportunities Act. However, the Opportunities Act does not address the factors that may disqualify an individual from employment. So it creates no substantive right. It basically just mandates that a process has to be followed. The Urbana Human Rights Ordinance, to draw a distinction, basically creates that protected class, which means that the only way that you can discriminate based upon that protected class is when it is reasonably necessary for your business operations. That's a big deal. What that means is someone can be fully compliant with the procedural requirements of the Opportunities Act, right? And even the enforcement rule, but still violate the Urbana Human Rights Ordinance if their employer policy has exclusions for certain convictions that are not reasonably necessary to the operation of their business. Does that make sense to everyone? So some of the issues raised by the Opportunities Act that we're sort of dealing with and we've been dealing with. The first thing I want to point out is much of the criticism to the prior enforcement conviction rule that we received from business basically centered upon the fact that a business in Urbana would have the administrative costs associated with changing the applications in Urbana, because Urbana was the only one that was requiring that they, in a sense, ban the box. And as a result of that, that was unduly burdensome, or it created an undue burden for them, in that Urbana and maybe 3 or 4 other places, for instance, for a national business, would be the only places where such a question would be invalid. All right? Well, one thing that the Opportunities Act does is it pretty much invalidates that criticism, because it means that employers all across Illinois, if they have 15 or more employees, have to comply with this. And the interesting thing, because if you look at the penalties look very negligible. They look very low, and however, from a very strict sense, they're still violations of the law, regardless of what the penalties are. So the argument from a business that this is going to constitute an extra cost, or that Urbana is going to cost them extra money in terms of their administrative costs, I think probably has been nullified by the passage of this. And that's one of the reasons I've been sort of monitoring this legislation as it's gone along, and sort of held off on issuing the response to many of the comments, because I thought at some point this is going to happen and we're going to be at this place, and we're here now. Now, there are some key questions, and the first question I think we should be considering is, does the Opportunities Act as a state law preempt the enforcement rule? Because they are covering the exact same process. And so that's one of the questions that we will pose to our legal division. What I would suggest to the commission at this point is that we should consider the possibility that it may.
So most state laws that preempt, where preempt means we can't add additional stuff, right? Most of them that I know of, because I had a couple with the Cable Commission come up, actually say that they are specifically disallowing home rule to take effect for that particular set of stuff.
Right, but that's not necessary. And
Okay.
in fact, and in some cases, there is language in the state law that says, well, this isn't really meant to necessarily preempt.
So it undoes.
Or it doesn't prevent someone from making additional laws or more stringent laws, where there are isolated instances where even in those cases there was a question of preemption.
So this one is silent on the topic.
Yes.
Okay.
Yeah.
I've been
so-
scanning through, so I wasn't
Yeah.
sure.
And it seems sort of like a semantic distinction because our procedures are so close. One of the things I would ask everyone to consider, though, is there may be some advantage in allowing the state to enforce this portion, but making sure that everyone knows that in terms of the substantive right, the substantive protected class, that is something that is protected in the city of Urbana. Because the whole point of passing, or at least for me as an enforcement person, the point of passing the rule and requiring that people be notified, basically, if they're being turned down based upon their prior conviction, is so that person could make an informed decision as to whether or not they felt that that decision was fair or not, and if they thought it was unfair, then they could come to the Human Relations Office and lodge that charge, which is, it's much easier to detect those types of discrimination when you're African American, when it's based upon race, or when it's based upon your sexual orientation. It's much more difficult when it is based upon prior conviction. And particularly when someone, as I've red that some employers do will take anything that has a check mark yes under felony conviction and basically discard those from the very beginning of the process. It is very difficult for an individual to determine whether or not that may have been a factor. Well, in the case of the state law now, and the point of the enforcement rule was to basically have employers declare, look, we've made you a conditional offer of employment, and the reason we're not able to extend employment to you is based upon your prior conviction for this, and because it has this type of connection to the job. That now brings those cases into the light and helps us to be able to begin to work through those issues as a community.
It also gives the applicant the opportunity to dispute any findings through either the organization's own background check or a third-party background check.
Which is very important because the records, experience has shown that those records are not always accurate. And particularly when the records are not provided by the official agencies, by the county governments in which the convictions occurred and are supplied by third party or sort of down the line vendors, it can often be erroneous. And so it's very important to give applicants an opportunity to challenge or to correct any or offer corrections and offer documentation for any false information that may occur. So what I will say is this: if there is some type of preemption, or whether or not there's preemption, there may be a strategic advantage in deferring that portion of the enforcement to the state. And that's something that we can talk about, particularly bringing in the legal division and having them, first of all, tell us whether or not preemption may be an issue here. And the way it would play itself out is we would go and try and do an enforcement action, and the employer would turn around and say, this is a state law. You all can't have an action for the exact same thing. And they take us to court, and then we have to deal with the preemption issue there. And am I saying that that will happen? No, we just don't know. I don't know because I'm not a lawyer. However, that's something that we'd like the legal division to sort of look into for us. But even if that were to happen, even if we were to say that there was preemption and that that portion of the enforcement would be not in the realm of what we're doing, it doesn't affect at all the substantive right that the Urbana Human Rights Ordinance gives to individual individual applicants for employment or for housing or whatever. Does that make sense? And I think that's it for, so I have a couple of recommendations. The first recommendation is that we basically go on a huge marketing and educational push to let everyone know, first of all, about the state law and about its requirements, and also to let people know about the right that they have in Urbana. Because again, if the point here is to uncover cases that may, and issues that may basically be under our radar at this point, this would be a very good way to get the word out that this, first of all, this is a state law that's going to be required. So regardless of whether or not Urbana is doing this, it is a required element of state law. But also, once you are informed that you were not given a position based upon your prior conviction, you have some redress. You have some ability to raise a serious challenge to that or questions about that. And it's important not just for applicants to know that, but extremely important for employers to know that. And so one of the things I would like to do is begin doing more advertising and more notices on UPTV and actually doing presentations, maybe bringing someone in from the state and doing several presentations over the next 3 months to really help people understand in depth how this law is going to be enforced and how it's going to interact with the Urbana Human Rights Ordinance. And then secondly, again, I mentioned this before, we're going to request that the legal division provide guidance and a recommendation regarding this potential state preemption issue.
Question in regards to education from the perspective of, in many cases I'm asked to speak on job interview skills, et cetera, for people utilizing services that are not necessarily in Urbana, but job-seeking in Urbana, that appropriate place to bring
Absolutely. If
this?
they're seeking jobs in Urbana,
Okay.
you don't have to be an Urbana resident.
Perfect.
It counts for employment in the city of Urbana.
Okay. Do you want, in those kinds of situations, do you want approved curriculum of any kind on talking points, et cetera?
You know what? Yeah, I can go ahead and generate that. It's probably going to be very much in alignment with what you're seeing here. Maybe
Yeah.
a little bit more information, but very much in alignment with what you're seeing here.
So I would very much like us to be in as much alignment with the state if we preserve the rule.
Yes. Okay.
Then the front end should be as close to the state, if not exactly what the state is doing, with only the exceptions that we think are additional things that we need for our local ordinance.
Yes, sir. And one of those exceptions would be the 15 or fewer rule,
Right.
or 15 or more rule.
And
it would count for everyone.
And
in
I think
Urbana.
that would, I'd be perfectly comfortable with that. The two things then I would say by way of recommendation is to have you kind of lay out specifically how we would do it, right? Okay, here's where the state stuff kicks in, here's where Urbana stuff kicks in. And have a plan for, if we're going to do it sort of one after the other, how that would work. The second recommendation, and actually I'd like you to look into how we might do this, is if there are going to be administrative rules from the department, whether we could make a comment as a commission as to how those rules are set up so that they align with what we want to do with the local ordinance.
Well, I will tell you, if it's an administrative rulemaking process, we will always have an opportunity to comment as an entity or even as individuals.
And you know, when that time comes around, I assume you're going to be notified of it just by way of all of the stuff you normally do. To have the commission prepared, and maybe you can prepare in the course of this, how the two rules will align. Because I can imagine, for instance, the administrative rule that the Department of Labor comes up with might have a thing about when you present notices, what things you have to give to each one, and we might want to recommend, hey, these are the things that would satisfy our ordinance very well, so that if you can make that the place where you notify potential employees of this, that, or the other thing, that way we could keep the alignment as close as possible. I would expect that the two things that I'm noticing, and I did take a look online, it's a very short little statute, so there might be a lot of holes to be filled in. The two things that I noticed that I think would be important to us are, if you are, if you have that exception, we're going to want to say it's on a per position or per job basis, where it's not clear. It looks like it might be employment-based, but employer-based, but it's not for sure. And the other bit is, once you've made the determination that you're not going to hire, it looks like on the state case, you can advertise up front, these are the things I won't hire for, because you can say, these are the convictions that I will exclude. For our ordinance, we're going to want to have that employee or present reasons that would be an exception to our ordinance. It wasn't,
But the exclusions, the published exclusions, are based upon, well, it's federal or state law and employer policy. So
it's
you're
the
absolutely
employer
right.
policy part
Yeah.
that's tricky.
Yeah.
If the employer says,
that out.
I am hereby advertising that I will not hire anyone with a conviction for possession of marijuana, at least as far as I can tell under state law, that's permissible, and it would not be
Right.
permissible under the ordinance.
Exactly. And, you know, I would say, for instance, those two places of sort of sunlight between the enforcement rule and the Opportunities Act, it's in those particular instances where preemption becomes really important.
Yep.
And where, as an employer, if you could think about it from their perspective, they're thinking, okay, I have two almost identical procedures to follow that I'm legally bound to follow, except there are these small differences on the margins. And am I accountable for those small differences, or can I just implement statewide this state plan? And that's why I have the question about preemption, because otherwise, most of the time when human rights legislation comes down, it's just not something that I think about much. In this case, when I saw those gaps between our enforcement rule and the state, it becomes important.
And the particular one I'm thinking of with this being able to list convictions.
Right.
I think what we'd want to be able to say as a city is, if you list convictions there, you better be prepared with why those particular convictions, the behavior associated with those particular convictions, would be disqualifying as a job qualification.
Right.
And if you advertise something that is not, you're going to risk being in violation of the local ordinance.
So what we're going to do, based upon those recommendations and based upon the research that we already will need legal to do, what I'll try to do is get together with legal, and hopefully we can provide a memo that sort of lays these things out in narrative form initially, so that we can all sort of think about and see it very clearly what are some of the limitations. Because your first statement that there should be as close alignment between the rule and the act, I think has much more import and prescience than it may seem at first. Because I think that there will be significant problems with implementation if there are these gaps that remain, and we got to figure out what to do with them. And so, in a very real way, the passage of the law is a great thing for the underlying principle that the city of Urbana has been committed to, right? However, there may be some difficulty in the details, particularly in regards to those specific areas of sort of non-congruence between the two.
There's many laws and regulations, though, that are different at the federal, state, and local levels. And in most cases, if it's in more favor of the applicant or employee or et cetera, it's usually okay.
Right, and in most cases, human rights,
Yeah.
particularly human rights laws, you can make them as stringent within some
Yeah.
bounds of reasonability as you would like. And there's not really a preemption issue.
Right.
I think this may end up being different
Well, it depends
ultimately.
on the ultimate burden on the employer and how they could prove that burden and what that burden was, or is. I'm curious as to how we plan to align with the EEO, if we planned, EEO guidelines. The EEO has guidelines for alignment of past convictions to employment decisions, and so if we will be considering those at all.
Yeah, so the EEOC
Right.
has published its sort of guidelines, its
Right.
enforcement guidelines. And what we did is we actually took the factors that where they're saying you should be doing an individual assessment of each conviction. We've taken those factors and they're incorporated into the rule. So all of the factors, time since conviction, age at the time of conviction, the circumstances or manner of the conduct that led to the conviction, all of those things.
Alignment to job.
Yeah, all of those things are sort of listed in the enforcement rule, and they're taken right from that guidance, from the EEOC guidance.
Do we differ at all from any of them?
I'm sorry?
Do we differ at all from any of those guidelines?
Only in the most sort of technical, minute way. For instance, there was some issue, if I'm recalling correctly, about bonding. And I just sort of reworded it and rewrote it to be more appropriate for a municipality, that type of thing. Because I think they were thinking about private employers, and this is obviously, well, no, there was some, it wasn't that, there was some other distinction where I had to just, but it's very, very slight, and it's very sort of technical. It's not,
Yeah.
it doesn't affect the substantive analysis.
Thank you.
Any other questions about this? I would encourage everybody to go off and read it. It is very short, take you about 10 minutes.
Thank you.
And it's also would be helpful to read the press about it, because there's an article in Forbes about it, an article, I believe, in the New York Times about it, about Illinois joining the bandwagon of Ban the Box or something like that.
I would be interested in helping in any way I can in regards to the education of this to our community.
So any additional questions on that? All right. And
Nope, just gonna say thank you. What do we got up next?
we've got the difficult thing, the EEO compliance program. All right, so after much thought and much consideration, what I've done is I've put together a memo that basically lays out our compliance plan goals, and lays out recommendations for improving the compliance plan, rather than sort of taking a more, I guess, targeted approach with unions. What I'd like to do is take a look at the entire program and see if we can't get some gains in the entire program. Because based upon some informal conversations that I've had, first of all, I'm not exactly sure of the net value of sort of doing a lengthy and detailed investigation of the local union membership and composition. But also, I think there might be some ability to leverage what's already being done in order to make some bigger gains and bigger strides. Now, I'm just going to review this very, very quickly. So the overview is that the whole point of the EEO compliance program is to remediate or to remedy the underutilization of minorities and females in contracting and to a lesser extent in vending. We've laid out sort of what the enforced EEO contract compliant enforcement approach is, and it's laid out in section 219 of the Urbana City Code. And basically, if you meet a particular threshold of spending, or if we spend a particular amount of money or a minimum threshold with a vendor or a contractor, they are then obligated to become certified as an EEO or to receive EEO certification from the city. And it is the Human Relations Commission that is responsible for overseeing that certification program. The next section basically discusses what is our current utilization. All right? So if you look at all of our companies in the aggregate that have done business with us since 2006, those companies are 23.6% minority and 47.2% female. All right? If you just look at the people who are currently contracting with us, those are 17.8% minority and 40.1% female. Those numbers look decent, very good, but that is misleading, because what we've done is we've lumped together giant companies who generally have very strong and robust diversity programs and smaller companies that tend to struggle with it, and vendors who typically do much better than construction contractors. When you break those two elements out and those two segments out, then the issue becomes much more apparent. So if you're talking about an average workforce availability for minorities in Champaign, right around plus or minus 2%, right around 15%, right? Then if you look at minority utilization among small employers, that's 500 employees or less, it's about 11.9% overall for overall minorities, 5.1% African American, 22.9% female. And then when you look at the utilization among contractors, it's right around 15.5% for everyone, and 3.8% for African Americans and 10.7% for female. Yes?
Do we count under the minority column in our numbers female?
No. That's why I've tried to break them
Okay,
out.
so yeah, that 11.9% and that 15.5% is not what we've ever looked at.
No.
That's not a real number. That's combining female and minority.
No.
Oh, okay.
We're not. So 11.9% is minority.
Is African American, Latino?
Yes, is the combined minority
okay.
utilization.
Asian and
Yes.
and Native
It's
American.
5.1% I'm just pointing out the African American one because.
That helped.
Yes, I'm sorry.
I thought you were combining female in there.
No.
in some way,
And
that
then
just
I've
seemed
also
weird.
broken out female at 22.9%.
Excellent. Okay, that makes more sense. Thank you.
So you can see they're struggling much more. And I can tell you that if we broke it down even further to employers with less than 250 employees or 100 employees, the smaller you get, which, by the way, the vast majority of Urbana employers and Champaign-Urbana employees are in that range, the
worse the numbers get.
I was going to say less optimal, but yeah, the worse the numbers get, right? And so the question is, how do we improve this utilization amongst our vendors? And okay,
So I've got a question going up to the previous section.
sure.
One of the reasons we started this discussion about unions in particular was because we encountered an employer who used a lot of union workforce, and therefore their claim was the numbers were terrible because the union numbers were terrible.
Right.
One of the things that's required in Section 2119 is that we get the same kinds of numbers from unions that we get from employers. And we have, to date, as far as I understood, not collected those numbers. So we don't actually know the makeup of unions in this city that we've been using as contract employment.
Right. And again, in informal discussions, the question has been whether or not, first of all, having that information gives us anything more in terms of the program itself, in terms of the effectiveness of the program, right? So let's just say I spend 20 hours overall sort of fighting this battle to get these numbers. Is there a discernible or anticipated impact, positive impact on the program? Because if there isn't, it would be better, the time would be better spent finding ways to positively impact the program. And that's what I said at the very beginning, that I've been giving this a lot of sort of hard, very careful thought and analysis, because I'm a guy who really likes to be compliant. When people ask me to do things, I really like to do them. It's only when I run into a situation like this where I say, we're going to expend some staff resources trying to sort of get this compliance, because it's never been done before, right? In the same way that the prior conviction rule and so I have to ask myself, in terms of the person who's responsible for the division, is this something that's going to net us anything in terms of actual gains? And it may that I'm not seeing, but I figured at least I would take a crack at suggesting some other alternatives to getting some similar and maybe even better results. So yes, I see exactly what you're saying. And yes, from a technical standpoint and under the law, we could require that every union that sends workers to anyone that contracts with the city of Urbana present us not only with their utilization numbers, but also with an affirmative action plan that we would have to be able to then approve. And that is absolutely correct under the law. That said, I'm not exactly sure in terms of the procedural mechanism what would happen and what, I don't want to say the point of it, but whether or not the energy and resources that would be expended in getting that information and in bringing that online would ultimately net us sort of
How it
some
would
type of
affect the outcome.
commensurate value. I'm sorry?
How it would affect the outcome.
Yeah. So, any other questions about that as a background before I get into the discussion of the recommendations? Okay, I have two very simple recommendations. Well, the first one's not very simple. So, I don't know how familiar everyone is with disadvantaged business enterprise programs, but they are typically programs that allow a public entity to set utilization goals for subcontractors on publicly funded projects. I hope I'm saying that correctly. And so if we have a project, let's say out on Philo Road, and the entire project is a $100,000 project that we're anticipating, we could, if we had a formal DBE program, we could tell the prime contractor that in order, or the prime contractors that in order to be in order to qualify to bid on the project and be awarded the bid, they had to meet a specific goal in terms of their utilization of minority and or female contractors for that particular project. If we set the goal at 10%, then we would anticipate that $10,000 of the entire project budget be allocated for subcontracting by minority and female vendors, right? Currently, the state does this, the university does this, anyone that's affiliated with the state, and they certify people through IDOT and through various means. The hinge is that in order to have a legally defensible DBE program, my understanding is there has to be some showing that there has been historical underutilization of whatever groups that you're trying to benefit through the program. And that is not something that the city of Urbana has done. And it can be very costly, it can take quite a bit of time, and there are some times when the disparity study is not able to establish, based upon the evidence, that that disparity has existed. Right? And the problem is, if you implement a DBE program without having that type of information available, then when it's subject to legal challenge, like for instance for reverse discrimination, it may not, and this is my understanding based upon sort of the education that I've had in terms of reading and talking to the individuals who are involved, it may not sort of pass that muster. And so I have an alternative to propose. And that alternative is this. We often see contractors whose utilization numbers are far below what we would think to be optimal or ideal. In those cases, what we then ask those contractors to do is to provide documentation of good faith efforts made towards diversifying their workforces. What I am proposing here is that we create and I didn't put this in here, that basically we create a registry of local minority contractors and local female-owned contractors that basically provide us with their information and provide us with a profile of the services that they provide. And so that when we have these contractors, these prime contractors that are having difficulty in getting their utilization numbers to a level that would be, again, more optimal, what we can do is offer them the opportunity to take on subcontractors, and by doing that, fulfill the good faith effort requirement. Sure.
So, in general, I'm a bit dubious about DBE programs, because DBE programs are about ownership of the business.
Sure.
And what our reviews have always traditionally been is about workforce diversity. So the fact that a particular contractor with the city says, okay, I will go and hire one or two small DBE contractors, especially if we do female-owned, does not address the real kinds of diversity problems that we're seeing with these contractors. So I'm at first concerned that what we're going to do is make these so-called good faith efforts look much better than they are. that they're really not going to address the true diversity issues in a workforce, and especially for some of the construction contractors, where what we want is not owners who are diverse of subcontractors, but we want the actual workers who are more low-paid folks who we think are probably getting discriminated against. It's a positive step. I don't want to say that all work with DBE programs is a bad idea. I think it's a good thing, but I think for the particular kinds of problems that we're seeing, I don't think it really addresses the concerns. The other thing that's not going to be addressed by this is if we have a company that's hiring almost exclusively union workers, this doesn't address the makeup of those union workers who are being hired by the company, because hiring subcontractors that are DBEs are not necessarily going to involve union workers. So I'm not sure we're really addressing the problems that we're seeing by moving to this kind of model.
Can I sort of respond to, so one of the interesting things about sort of taking this approach is, for instance, if we find that an employer is doing fine on female-owned or female utilization, which is often the case, and they're not doing well on minority, we can offer as a good faith effort finding a minority contractor. We wouldn't do both, because I absolutely agree with you. What sort of the anecdotal findings, I'll just put it this way, is that with female-owned contractors, oftentimes having female ownership does not necessarily increase the probability or the utilization of minorities and female within the workforce of that particular female-owned business or enterprise. However, when you go to minorities, there is an increase. It's not a guarantee, absolutely, but there is an increase. And I guess to address the unionization issue, part of what this does and part of what this is meant to do, it's not meant to solve the problem in one fell swoop, but what it's meant to do is to begin to increase the capacity of minority contractors locally, and to get more projects in their hands that are funded by the city of Urbana, quite frankly, and that will allow them to take on more and larger projects. The university has been doing this for years, and they are sort of at the bleeding edge of this kind of work. And this would be meant to sort of tag along onto that type of work, increasing capacity of particularly minority contractors locally, to then increase the likelihood that they're going to have people who are qualified to get into these trade unions.
And to that, I think that's a good approach and something we definitely should consider doing. Champaign actually took an additional step of subdividing their contracts all the time into smaller chunks so that smaller businesses, which the minority contractors in town tend to be, get an easier shot at a piece of that contract without having to depend on the primary contractor to hire those subs.
And at this point, I'm not prepared to make that type of announcement, but that is something that is being actively looked into.
So I think those kinds of programs are great, and we should certainly be doing more of that stuff. I agree with you that it seems like for minority-owned businesses as opposed to female-owned businesses, we will get some increase in diversity out of that, and that's a good thing. The really bothersome numbers that we're seeing, I'm not convinced that having one of those contractors hire one or two subs that happen to be minority-owned is really going to put a dent in their kinds of problems.
But certainly it'll make a difference to those minorities.
It'll certainly make a difference to those minority contractors.
Well, and it's my understanding that the bigger issue in regards to the original issue of the unions is, have we looked at the minority status from a local, state, national perspective in regards to how diverse those types of businesses are to begin with? And is this more trying to address this issue locally that is more of a systemic issue that we may not be able to address at that scale?
And what I will say is this, because we do have that understanding. Membership in trade unions traditionally has been very much skewed, right? However, when you're closer to an urban center, your membership numbers and your utilization numbers improve greatly. And I mean, it is very much like everything else in the United States. It depends on where you're sampling. Nationally, the numbers are going to be not all that great, but there are going to be pockets where those numbers are much better in terms of trade unions and membership.
So what's the bigger concern in regards to, I'm just kind of curious as to, is the bigger concern the utilization of minorities for the job at hand, or is the bigger concern the utilization of minority employees as an organization, as a whole?
So, excuse me, I think we're trying to poke at a big problem with a little stick, and we're trying to sort of work the it's the finding the car keys under the street lamp problem, right? You look under the street lamp for your car keys because that's the easiest place to see. So we're looking at employment contracts with the city. And we're seeing if we can improve those numbers because that's what we have the ability to actually manipulate and actually do something about. The hope is that will have a knock-on effect citywide. I don't know that we've ever done a study to see that it does, but as Todd was saying, the ability to get minority contractors into business increases their profits, increases their growth, and therefore gives them the ability to take on more and more contracts, and that may have an effect citywide. So I think from my perspective, what we want to do is make sure that the folks that we're hiring as a city have good representation of minorities such that those workers are available, those folks are getting employed, and can start working for other folks outside of the city in the long term.
And it's my understanding that the subcontractors would most likely be local,
Yes.
and so the employees would be local, and therefore we would be increasing minority jobs locally by offering subcontract work opportunities that may not be getting it otherwise, because they
the
do not
hope.
meet our requirements for minority number employment.
Right.
One question that I've got, I know this came up with the UC2B contracts, that there was no way, and maybe it was because it was the university that was involved and it would not have taken place because of the cities, but that there was no way to encourage local minority hiring, which meant that if you had a big contractor come in for a contract, bidding on a contract, they could hire some minority or female-owned businesses elsewhere and still beat the local contractors because they got more points for doing that, and because they were a bigger contractor, were able to better qualify for the job on other grounds. We couldn't, I mean, we can provide them with a list, but we can't require that they hire from our list and still give them credit. If they have a minority contractor from someplace else, they still get the same credit under this program, correct?
Yes, but though that's one of those problems that I would say you start the program, and if you see that as a repeating pattern, then you begin to think about how to correct it. Because to be quite honest with you, with the local contracts that we have, I would be very surprised if some sub is willing to come in for
Just for that.
what is relatively a small amount of money.
And
I mean, what you're talking about, that was a large project.
Right, and the problems that we're seeing are with the smaller contractors
Yeah,
anyway,
anyway,
which we
yeah.
think are going to be mostly local.
Yeah.
So.
But I think that's something we do need to monitor. Sir?
I'm just, overall, my initial response, even though I understand the concerns addressed here, my overall response is more minority jobs for local employees local citizens, I'd have to know what more negative pieces are to not suggest that we go with something similar or a modified version of something like this, because it would be nice to know, it would be nice to have a registry of contractors that meet our requirements that then could be utilized as subcontractors. It just seems from a 20,000-foot level like a win-win for both the contractor and for local citizens.
And I think I agree to the extent that these kinds of programs are useful and important. I would prefer to see this kind of program, either a true DBE or this modified DBE, in terms, as part of the kind of thing that you're studying with regard to smaller city contracts so that we can give more opportunities to those smaller businesses. I think that's a positive thing. I'm not clear that this addresses the problem that we saw with union participation in some of our contractors, and I'm not sure that this is going to have that much of an effect on that problem. And we still don't see the numbers from the unions to see if that is in fact a real problem in this town, and I, for one, would like to at least know what we're dealing with.
All right. And again, I think we can start down that path that's, I don't want to say if it's absolutely necessary, but I anticipate that that's going to be a pretty time-consuming and resource-intensive path, relative to the gains made. But one other thing before, I just want to mention the second recommendation, which is basically providing additional financial support to local trade unions who have specific programs that are targeted to underutilized groups. And they exist through my conversations with them over the course of 2 years. You know, there are certain programs that they are currently sponsoring at Parkland and some other trade schools to basically help get more underutilized groups in the door, get them trained up so that they can become apprentices. I think that this is another opportunity somewhat for a win-win. You know, we don't want to go in the business, obviously, of training people for unions. I mean, it is obviously leveraging the union's expertise and their ability to screen people into these programs. And so as we find those programs, and I think there are a couple that we've seen that are doing a pretty good job of it, sending some type of support and helping them with advertising the programs, particularly in the high schools, I think may ultimately, in the long term, get closer to the specific goal of increasing minority participation in unions. But again, it's a small thing, but it's a thing that may end up netting a positive result.
I totally agree. This is stuff that we want to encourage, and whether it's HRC support or we need to go to the city and say, how about a little more financial support for these things? Not the best time financially for the city, but I think this is important, and I think we should bring it to them. But I have a suspicion that the programs that we're seeing that are run now are probably being run not by the unions that we fear are the real problem. That the folks who are actively recruiting minorities and females into the union, if we were to look at the numbers, if we were to do the process with the unions, they would present us, we've got these programs in place and we would be happy to encourage those financially. But we would find that to be good faith effort to try and improve the numbers, and that would make us perfectly happy. I think we are all sort of carefully walking around the possibility that there are a union or two out there that are not engaged in these kind of programs, that their numbers are terrible, that they're not doing anything about it, and that we suspect there's a reason they're not doing anything about it, which is why I'm pressing on the more information might be helpful. One of the questions I had as you were describing this is your concern that this is going to be a big investment of energy on the part of your office, that you're going to meet resistance by some of the unions, whether or not they're doing a good job, or that it's just going to be the sheer number of people involved, it's going to be a lot of administrative cost?
I'm anticipating at least some resistance. I could be very wrong about that, but based upon some informal conversations, I'm anticipating at least some resistance.
Okay.
I may be wrong. I often am.
So are we all.
So any additional questions on that? So I will again be about the business of trying to get the numbers. Any additional questions on these recommendations, though? In the absence of a quorum, if we're just going to begin to move forward with sort of further outlining these plans and getting them going.
And I don't want you to take my comments to mean that I think there's something wrong with these plans. I think these
I
are
understand.
great things to move forward with. I'm just concerned that they're not, they might not address some of the issues that we're seeing,
Yeah.
and that I think there are other things we might want to be doing.
Sure, yeah. So we're going to move forward and then give you periodic reports on progress. Any additional questions?
I have one, sorry. In the situation that we're kind of tiptoeing around and trying to apply these solutions to, how stuck do you believe the employer is in using only one union for an employment base? Like, because I think if there's only one group for which to get that type of worker from, then there are more concerns that make the issue even bigger than we might be addressing tonight.
I may be misinformed on this, and I quite honestly, that's an interesting question. I've always assumed, from the information I've seen, that unions are not particularly competitive when it comes to trade unions and construction unions. You have a local labor union, a local bricklayer union, a local electrical worker union, and not a whole lot, although that can occur. I just have never
Well, and that's
thought that exists locally. Yeah.
that's my understanding, and that's my concern in the situation of this in regards to what options does the employer have other than an active recruiting effort on their own.
Right. Right.
Which might not be looked upon kindly by the union.
I mean, when we initially started talking about this, it would be, I think, a real problem for us to pit minority hiring against union hiring. So, and to agree with Todd's sort of motivation here, whatever results in getting those minority hires such that, you know, we can encourage the unions to do the right thing, we can encourage employers to do the right thing without making it some sort of hard enforcement, absolutely is exactly what we want to do. On the other hand, we don't want to leave things just sort of tiptoed around and avoided.
Yeah, I agree.
I think we're done with that.
Oh, perhaps, unless there are other questions. Okay. So, hopefully we can move on to the approval of EEO workforce statistics. We don't have a quorum, but I think, Peter, you may have had some questions.
Yeah, I mean, so just by way of my impression, the renewals look, I mean, these are folks we've worked with before, and the renewals look like your recommendations are going to be okay. So if you're looking for a sense of the commission, I can say for myself that administrative approval if you need to, and we can bring these back on the next agenda, is not a problem. The question I really had was about the two new ones. And it brings up a somewhat broader issue. The Baker Tilly looked like an accountant of some sort, and is a rather large firm. And Applied Research Associates, I couldn't tell, but in neither case does it mention the contract that they're applying to take, and in neither case does it mention a contact information or department that they're talking to. And we've seen these sometimes, quite often before. The one that popped into my mind as plausibly problematic was particularly Baker Tilly, where I thought, okay, this is a Chicago-based employer. Chicago-based employer with not terribly good numbers, and is a large, apparently accounting services firm.
Yeah, that's,
And the first question that came to mind is, what department in the city is wanting to go to a Chicago-based accountant instead of to a local accountant? And why are we going with, given the number of financial and accounting firms, why are we going with someone with such terrible numbers?
so here's one thing that may or may not be the reason, or be something that addresses your concerns. So oftentimes, these contractors will apply for certification with us in anticipation of submitting a bid.
So they're pre-certified. They're trying to get pre-certified.
I'm not exactly sure in this particular case, but we can find that out, but that may be the case. In fact, it's more often the case than not. So you all are more often approving bidders than you are people who have been awarded contracts, if that makes any sense.
It does, but if that's the case, and I think I've sort of known that in the back of my mind for a while, we go back to a question we asked many years ago when we started this discussion of doing these approvals.
Right.
Shouldn't this impact the bidding process in some way?
Right.
If we come out with a review that says these people are doing a lousy job, shouldn't that somehow feed back into the bidding process and say, perhaps you don't want to hire this person, or perhaps you want to subtract points on the bid, or some other way of getting the information that we're reviewing back to the folks who are potentially going to contract with these people?
So essentially, the question of whether or not they're a qualified bidder.
Exactly.
And whether or not this has some bearing on their qualifications.
I mean, the auspices that we're doing these reviews under, 2119, is for contractors that have a significant contract. We're supposed to review those things, and the way we decided to do that was, well, we're going to review them and give them some sort of certification so the city can continue their work. If the work isn't even started yet,
Or not even.
perhaps not even going to happen.
Yeah.
Then you'd think that we would want to have a discussion about how our reviews feed into this process.
So that's a very excellent point, because this actually comes up quite often. In terms of, oftentimes we get calls from contractors that say, you know what, I'm going to put a bid in for this particular job. Could you please send me the EEO paperwork that we have to fill out so that we can become pre-certified to bid? And in that particular instance, or in fact, there are some that aren't even looking at specific bids. They're just saying, you know what, we're running out our renewal, we need a renewal, or we anticipate a year down the line that there might be a contract or might be a project, so we just want to take care of this now. That actually happens. It happens quite often. And if it's something where you're only wanting to see those awardees, the problem is, and I think this sort of gets to what you're talking about, is at the time of award or post-award, then if you're trying to affect whether or not they're a qualified bidder, you don't get to, because it's already been awarded. That said, we've never really had a case where a vendor was rejected based upon bad numbers. And you're right, 2119 appears to anticipate that there is an existing contract. And so the question is, in sort of the presence of that potential gap, first of all, is there a scope of authority under which the Human Relations Commission could say, we don't think you're qualified at this point, and so we don't think the bid should be awarded to you? Or is the enforcement authority, does it only govern once the award has been made?
So
And I don't know.
procedurally, what we've been doing, I think, the reason we did the 6-month, 1-year, 2-year
Right.
business was because we thought, okay, we've already got a contract in flight, and if we want to say this person isn't conforming to the ordinance,
Right.
then what we're basically saying is, because the way the ordinance is written, it becomes a per se contract violation, right? What we would then be saying is you violated the contract. So we were going to go for this slightly less draconian method where we'd say, okay, we're going to give them a 6-month or a 1-year permission to continue with the contract and try and improve things on a good faith basis. But if we're going to be in the business of actually looking at folks who have not gotten a contract yet, then especially, I mean, take Baker Tilly.
Right.
You're recommending 6 months because their numbers really stink.
Are suboptimal.
And
Yes.
and at that point, I would want to say to the city, if we haven't contracted with them yet, let's not, to abuse a metaphor here, tiptoe around this. This contractor with these numbers would not be doing a good job in terms of their equal opportunity employment hiring. And perhaps we should say, no, they're disqualified unless they want to come to us and show good faith efforts to change that right now. So I would want to revisit our procedures if that's what we're doing for these kind of cases.
So, one, I don't think it's in our privy to decide whether or not a contract, like whether we should use them or not. Even though I agree that we should be looking at local options if we can. Completely agree with that. I don't know if that's really necessarily our responsibility. One concern I have about pre-authorization is if, let's say that their numbers looked great. Let's say they were at 30% minority employment, and the contract never comes to fruition until 18 months from now. Those numbers can really change. And so we're hiring them on a contract based on numbers from 18 months prior and not holding them accountable to numbers now when the actual contract goes live. And I think that could be a problem. For me personally, from a business perspective, I think it's wise. I think it's, let's get this over with, let's be in the queue. I understand that perspective. From the commission's perspective, I think it puts us in a position where it almost doubles our work, because then we kind of have to double check to say, oh, did they actually get a contract? Yes, they did. Are they still meeting requirements? And that gap, we just don't want that gap to be too wide. So those are my concerns in regards to pre-authorization. I'm somewhat pro, but I think at the end I would vote against it just from the perspective of, I think what we could do in this situation is say, not ready. When a contract comes up, this is where we think you might want to focus your efforts so that when you reapply, you're better prepared for this. And that's how we respond to this. Somebody who's actually ready, we say, great, wonderful, thanks. However, we're going to ask for these numbers again upon actually having a contract with us.
With that feedback, there are, I guess, only 2 notes I would make. Number one, I think part of the problem may be with our competitive purchasing process. I think it's sort of a relic of, well, I'll put it this way. I don't think it's changed much in the last 20 years or so, right? And I think oftentimes when potential bidders receive our competitive purchasing packet that has the EEO information in it, oftentimes they're under the impression that they have to receive approval from the EEO in the same way that you would have to receive it from sort of the CPF process in order to be qualified to bid. And so I think, and I can tell you that the process needs retooling because, for instance, oftentimes they'll call me and ask me about the competitive purchasing side of things because our number is the only one sort of visible and available in the packet. And I don't know, I haven't received many of those calls, so maybe that's changed over the last couple of years. But that is something sort of that we encountered a lot. So I think it is worth revisiting the entire process to say, when are we approving these? Because in a sense, if I'm someone who is constantly preaching sort of efficient resource allocation, and we're burning resources on approving contractors that don't have contracts, which is exactly what we're doing, I'm not exactly sure that that is a great use of our time and resources.
Not only that, but we might actually exhaust more resources if they do become a contractor in double checking
Right.
those numbers later. So
Yeah, I'm going to take this feedback very seriously and have some serious conversations with our sort of finance people and with the public works people and try to get some feedback from them and concerns from them and see if we can't figure out maybe, because quite frankly, you're right, Peter, the current process does not really align particularly well with Section 2119. It doesn't marry very well with it. We've done our best to try and create procedures for us and for our working to make sure that if there's ever an issue that we can address it in a fair way that gives everyone due process. But quite frankly, you're right. The current process as it exists is pretty removed from what is anticipated in 2119.
So we do have this little clause in the ordinance about meeting with department heads.
Sure.
Maybe it's worth you getting together with the head of finance or maybe some other folks and having them, come down and let's have a little presentation on what would work best and how we might adjust our processes to better help finance. And, we hope that by doing this kind of thing, that what we're doing is encouraging city departments to hire folks that have good diversity. And if that's not having a real effect, if what we're doing is looking at the numbers and we're sending encouragement to these employers, but the city is not changing their hiring practices one way or the other, maybe we can do something different that will help the city do that and still fit in with, the rest of the city department's procedures. So.
Right. So, yeah, we can start to work on that.
how often does our process slow down a contract?
Not very often.
Okay.
I mean, because there are times when there's some type of exigency that requires that we do an administrative approval or something, but that's really rare. Because, if you think about sort of the CPF process from start to finish, oftentimes it will take the better part of a month or more than that. And that would encompass at least one meeting by us. And for instance, one of these contractors submitted their information today. Is that correct? And we were able to get it to you and in front of you today. So we're very, very flexible, so it's very rare that we are the ones, in terms of this process, would be the ones holding up a contract. So I think there are valid concerns and valid points, and I think it's time and I think it's been in the back of my mind for years that this seems a little strange, and now that you've brought it up and sort of brought it into the light of day, I'm delighted to work on it. Any other questions in regards to the EEO compliance? Okay, great. Our workforce statistics. All right, if it's okay with everyone, I'd like to move to the HRO activity report. And looking at the monthly complaint activity report, since the last time we've met, I think we've had 2 issues. There's actually one more that came in today. Obviously, it didn't get on here, but it was an employment issue. And I've been dealing with a housing issue that I don't think has been reflected here either. but that was something that's referred on to our building safety people. Any questions?
That's not the housing one second from the
No,
bottom?
it's a different one.
Okay.
And they tend to come a lot at this time of year because you've got people moving in. All right, looking at the monthly complaint activity report, the first report I would have is about the case that was pending the public hearing. And I've still not received sort of feedback from the attorney, so I am going to call Mr. Jackson and ask that he intervene to find out exactly what's going on. Looking at the ones that we currently have pending, I'm actually writing 2 initial determinations. And then the public accommodations case, I'm going to submit for legal review to determine whether or not, given sort of the circumstances of this, it's an odd case, the circumstances of this complaint and charge, whether or not there's really a legal basis under the ordinance to continue to sustain a charge. And most of the time I can answer that question. This is a little off the beaten path, and it'll take some work by Michelle to kind of help me to understand where to go with it. Any questions on that?
One quick one. When you do, you say you're drafting an initial determination, that's your probable cause finding?
Yes.
So do those become public, or
If they are probable cause,
Mm-hmm.
yes, they are
Okay.
a public document. They don't automatically become public.
Right.
But they are a public document.
I guess one question is, will you show us those next meeting if once they're written? Or
Yes, I'm trying to, I'm
have we
not-
done that in the past? I just don't even know.
No, if it's a no probable cause, then no.
Right.
Because that still remains sort of under sort of the cloak of privacy.
Right.
If it's a probable cause, the problem with showing you the probable cause determination is that you guys are going to be the ones, if it goes to hearing, who have
to listen to the.
Yeah.
Right.
Yeah.
Right. So, okay.
And actually,
Good point.
it's a problem to show you the no probable, even if we wanted to show you the no probable cause, they can be appealed.
Right, and then
Yeah,
have to
now
hear
that
the
I'm
appeal,
thinking-
and, yeah,
yeah.
that makes sense. Okay, that's why I asked the question.
And I don't believe there are any changes to our budget for this month. Or were there changes? Oh, it's here. Sorry, and Tony has very helpfully underlined, there was the donation to the city of Champaign, which is part of our intergovernmental agreement to provide sponsorship to the Champaign-Urbana International Humanitarian Awards, and so that was for $1,200. And in fact, that leads me to my announcement that I wanted to make, which is a reminder that the Champaign-Urbana International Humanitarian Awards will be held on September 25th. I believe it starts at 6:30, if I'm not mistaken. Yeah, the reception starts at 5:30, and it's normally a great program. I think they have a great program planned for this year, and I would encourage anybody who is interested in going. I think the city still actually has a couple of tickets, so please see me if that's something you're interested in doing. Yeah, we've got 2 or 3 more tickets. And if need be, I've got money in my office budget that I could probably help, because it's a great experience, and I'd hate for anybody who wants to go, particularly from the HRC, to miss that. It's an opportunity to see what local people are doing to impact the world. And in the past, like for instance, one of the most memorable awards that we gave was for a group that developed a way of teaching very sort of critical issues to individuals who don't read. So for instance, for health issues, they actually developed a way through pictures, to help educate people on particular vaccination needs for particular vaccinations or particular preventative health measures, or even they've done agricultural types of education with it. And it's just a great program. Or another program that was designed to get cell phones in the hands of agricultural workers and farmers in underdeveloped countries, because that actually automatically has an improving effect on their ability, or has a positive effect on their ability to actually generate income through their agricultural products and grow their crops in a more efficient way. So there are just some great things that are happening sort of, and that are coming from right here in Champaign-Urbana.
Are there any other announcements? Then this meeting is adjourned.